if you'll let me know or send me a message or something. So, okay, so thank you all. My name is Mark Travis. I'm the moderator for this session on the future of the labor arbitration process. Looking ahead 10 to 15 years with all the changes that we've seen in the last year, and what does that portend for us going forward for 10 or 15 years. This is, before we get into the meat of the discussion, we don't want to go there without first recognizing that this entire series, the 3 sessions today and the other 3 sessions before and the 3 sessions that will follow in April are all dedicated to Professor David Lipsky of Cornell, who has been a past president of LIRA and as a mentor to, frankly, anybody that's in this field has benefited from David's relationships and his knowledge and his friendship. And so we don't want to go any farther without recognizing that this entire series is devoted to David Lipsky's work and mentoring in this area. Having done that, I don't know if David is on. I hope he is, but beyond that, let me kind of give the framework. I said we're looking 10 to 15 years ahead. Now we've got two sessions remaining today, and I want to explain. This little slide actually is flipped to one extent. This is the first session on labor arbitration. It is the one that is focused on the future of the process and the procedures. This is actually reversed here. So I like to look at this as saying this hour-long session that we have is looking at the micro process, if you will, the arbitration process internally. The second session will deal more with the legal and the structural, the environmental, if you will, framework in which we operate, more of a macro view of the labor arbitration world. So this is the micro. We'll get to the macro in the next session. So that may guide your questions and guide the discussion to some extent. And so that sort of leads, in terms of guiding the discussion, not to take too much away from what we're going to be doing, but we need to kind of lay the ground rules out, the rules of the road today. This is an unrehearsed discussion, roundtable of the presenters, and we'll introduce those in a minute or two. This is not, as you will see, death by PowerPoint. The PowerPoints are just simply here to guide our discussion, and it's a roundtable discussion, and that is what it is. You are muted. You should be muted. I think it's set up in such a way that that's the default mechanism. The way we're trying to monitor these is, I think probably most of you have been in the other sessions as well, a majority, I would bet. The chat function will be used to ask questions. And so we're not going to take questions during the process. We have a chat monitor. That's not me. That's Mark Goff will be doing the chat monitor. And at the end of the session, we'll reserve enough time to hopefully answer whatever questions and sort of congeal those questions at the end to get a framework for covering as many of those as possible. The session is recorded. You can go back and watch them after today if you have to pop out or whatever. I know because I've looked at the ones from the last session. So that's going to be available on the LIRA website if you've registered, and we will end promptly at the hour mark because we have the next one following 15 minutes after the end of this. So with that, let me introduce our presenters or discussants, if you will. We have Arthur Perlstein, who's the Director of Arbitration at the Federal Mediation and Conciliation Service. We also have Frank Benda, who is an Assistant Vice President at the American Arbitration Association. And did Jeannie happen to?
I'm here.
He's there.
Yay, thanks, Jeannie. Thank you. Jeannie is an arbitrator and mediator. She's a member of the National Academy, and importantly has been, and I think still is, the chair the video conferencing task force. Is that still correct, Jeannie?
That is correct.
Great. Okay. Again, Mark Travis. I'm a mediator and arbitrator located in Tennessee, and also proudly an Academy member. So again, this is unrehearsed, and we want to just kind of launch into the discussion now. So and I don't have any designated assignments, and I'm going to ask for volunteers from any of our presenters here. And there's been a lot of discussion about, is the virtual arbitration, remote arbitration in the labor world, is it going to remain the norm, or will we see hybrid? And I open that up to anybody, any of the presenters, for their feedback on that.
So
Jeannie?
I'll be happy to start.
Yeah, great.
Since I have been actively speaking to colleagues and parties about this, and what I'm finding is that this was a game changer. This unintended year-long experiment that we've had with virtual hearings is, I think, here to stay. And I would echo a lot of the comments made by the previous panel that, for all the same reasons, the efficiency, the ability to move the cases along more expediently. You don't have the travel days you have to build in. And that's not only a benefit to the neutral and the arbitrator in my case, because I was traveling quite a bit for arbitration. But I think also the advocates as well. I think they are finding that they're more efficient when it comes to prepping their case and being able to meet with a witness without having to do a trip out and then do another trip for the hearing itself. So I think for those reasons, I think it's here to stay. And I've even heard comment about workplaces that may be in remote locations that are very difficult and costly to get to, that this provides an advantage for even managing those cases.
Arthur, what are you seeing?
Well, I agree with Jeannie, and I couldn't help but notice that she seems to, but Bernadette as well, seemed to have stolen some of my sunflowers. But I agree. I actually, long before COVID, I had thought that this was going to be a trend, but it had been a very slow trend. Now that everybody's been exposed to it, I think it makes a huge difference, and I think we're going to see lots more of it. Sometimes in hybrid form, a lot more use of remote witnesses who can't easily make it, and that sort of thing. But I think, you're going to see considerably more hearings, that are virtual. One of the things that I have seen that I hope will settle down, but I've seen a lot of this, is conflict over the issue of how are we going to do this in any particular case, where one party wants one thing, the other party wants another thing, and the arbitrator is either stuck in the middle or only wants one of the things, and it becomes a controversy. And I don't like to point fingers, so I won't point them very specifically, but I have seen what I believe are the use of this, sort of the old Groucho Marx, whatever it is, I'm against it, as a delay and disruption tactic. In fact, there was one actual case, this was a federal sector case, where a management in one arbitration had objected to having it done virtually, because you couldn't get credibility and so forth. And then in another arbitration, turned around and took exactly the opposite view. They said, in person was too dangerous for our health, and so on and so forth. Once we're past COVID, it won't be the health issue, but I think at least for a while, you'll continue to see this struggle. I hope it becomes more of the norm so that more parties are willing to do it, at least in appropriate circumstances.
Frank, have you this issue about the dispute over the forum? Have you seen? Well, number one, do you think it's going to be continuing its present trajectory? And number two, following up on what Arthur said, have you seen this dispute about did it being turning into a substantive dispute between the parties?
We do see that on occasion. Luckily, it's rare. But we do find that sometimes the arbitrator maybe acts as a mediator to try to work through that. And very rarely, maybe I could count on my hand the number of cases where the arbitrator actually had to make a preliminary decision on how we're going to proceed on the case. So most times they do work it out. And I do think that this is something that's here to stay. It's been a boon, I think, because, for example, we have arbitrators up north. I'm up in Rhode Island, and they spend 4 months of the spring in Florida, and they would normally not book hearings. Now they can have the hearing, and they're poolside, and they can still do the hearing. So scheduling wise, it's been fantastic.
Okay, great. Yeah, I mean, just observation from myself as the moderator here. My experience is that the parties do get entrenched, and it's very hard to mediate that. That we're all mediators too, to some extent, but once they dig in, there's a reason for doing it, and it's sometimes hard to get buy-in and agreement on that. But
Mark,
go ahead, Jeannie.
I don't know if it's just been the luck of the draw, but I really have not had many disputes about it.
Really?
Early on, there was hesitancy. And as we all know, what parties tended to do was to just push it, kick the can down the road. But, we clearly got to the point where we could do that no longer. And, cases had to go forward. I mean, I'm at the place now where the parties, when they email me, this will be a remote hearing. So I don't have to introduce the idea. Either their workplace policy dictates that that's how these hearings will move forward, or they have determined among themselves that it's an effective way to conduct the hearing.
Consider yourself lucky. I would say about 15 to 20% of my professional time since about May has been spent dealing with problems on just this issue from arbitrators and or parties.
Yeah. And I guess it's probably, it may be certain sectors that may dictate it to some extent too. So I wish mine was as seamless as Jeannie's apparently is, but it hasn't been. But the next area I want to talk about a little bit is whether or not these hearings, our labor arbitration hearings, are going to be, well, this kind of goes hand in hand about will they become paperless? Will it become more digitized? I think probably along that same line, we can talk about court reporters too, because it all goes hand in hand of hopefully streamlining the process and not creating more work. So, Jeannie, what do you say?
So, and now that I have connected my my microphone, hopefully you can hear me better. I got a message in the chat. It wasn't connected before. So my apologies. I'm having all kind of issues today. Just be patient. This is one of the things that I tell the parties. What can go wrong will go wrong, but if we're patient, we'll work through it. So the paperless issue. So I actually love the fact that we are paperless. I was in the process of making my office paperless prior to this taking place. And then in those cases, like with railroad cases, they have huge document files for those cases. And so I have welcomed the ability to receive all of that electronically. Now, on the flip side of that, I have started to ask the parties to submit briefs and to receive the transcript in hard copy as well, only because just watching a computer screen all the time for all of my work, I find to be a little challenging. So I would like to have the flexibility to look at paper and not have to be studying from a computer screen all the time. But what I do say is that if you are going to make exchanges paperless or encourage paperless production of documents, that it's worthwhile to invest in those tools that help us manage electronic documents like file sharing service, um, the Adobe bookmarking, Bates numbering, all of those things that help to make it easy to manipulate and go through the documents. I think it's a worthwhile investment.
What are some of those? What are some of those resources again, Jeannie? So we can.
So, you know, you have Dropbox, you have, I guess some people use Google Drive, and that's a file sharing service, right? So the parties can just upload their documents. I've actually converted some of my forms to electronic version as well. For example, my appearance form that I would normally have the parties complete at the hearing, when, you know, at the outset of the hearing, I've converted that to a fillable PDF, and I just email it to them, have them to fill it out and send it to me so I have it at the beginning of the hearing. Initially I was filling it out myself from information that they would email to me, and I'm spelling it, you know, I'm not getting the names right and things would change. And so I just decided I didn't want to have to deal with that, and that they could put the information on there as they would in person. So um, then the bookmarking, I mean the bookmarking with Adobe. Adobe has, you know, most of us are familiar with the reader functionality of it, but it has a lot of options that are you have to that pay for in either packages or, you know, by themselves. But they have like redaction, they have the bookmarking function, which allows you to combine documents. For example, I opened up a case file this morning that I'm going to start studying, and I was able to put the brief, the exhibits, the case law that they cited, the transcript combined in one document, that the software then bookmarks the separations of each document, allows me to easily maneuver through the document. So I do ask the parties to do that on their end when they submit exhibits, if they have the capability to do so. So that's what I mean about those are some of the tools
Yeah.
that have been helpful for me.
I would add to that on the Adobe, and I use it sometimes if I'm not given a Word document, is the converter that will convert documents when you got a lot of text into Word to take a PDF and convert it. Not always fail safe, but it can save some typing. So Arthur, Frank, any thoughts about paperless? And we didn't really touch on court reporters yet, but any thoughts on what you're seeing there?
On paperless, I don't really have anything to add to what Jeannie said. I think there'll be gradually more and more use of paperless.
Yeah.
Yeah, and just so you know, the association, we've actually just created a exhibit storage area on our web file. So it's a secure place where they can be uploaded, and then the arbitrator and designated individuals can then have access to those exhibits. And literally, I think in the last week we went live with this. So, but it does on a per case basis, they can now go in and I think up to 75 meg file on a PDF and 16 meg on anything else. So that will help, I think, with some of the security concerns. And I do find that depending on the amount of documents and the size of the documents, some arbitrators are okay with just electronic transmission. But sometimes if it's something big, a lot of, many pages or lots of exhibits, they're going to want to at least at some point get hard copies of those exhibits.
Does this, that's interesting, Frank. What you're talking about is it similar to the web file that's used in employment cases? Is that what you're talking about? Does it operate pretty much the same way?
Yes, it's the same across all our platforms, just in labor. We haven't found a heavy use of it, but it's there. It's been there for labor, but now, of course, we have this new feature for just for exhibits, just for larger files.
Okay, all right. Okay, thanks. Jeannie, what about court reporters? Are you seeing a reduction since Zoom has a recording function? Are you seeing any reduction in court reporter utilization in arbitrations?
I have not as of yet. The parties who have used court reporters in the past, they are staying connected with those relationships, and that process has been staying in place. From what I can see, I don't know if there's going to be a shift, during next budget season, but
Yeah.
I like receiving the transcript. It makes
It'll
it
be
easier
interesting to see. I mean, two things. One is technology is advancing very, very rapidly as far as speech to text. Even now it can be done, although there's going to be lots of nonsensical words, but that's getting better and better. And I don't think we're that far away from when a computer program can do just about as well as a court reporter. On the other hand, I am seeing a number of arbitrators who aren't that comfortable with hosting using court reporter. There are lots of court, not all of them by any means, but there are lots of court reporters who will host these virtual arbitrations and do it well. And perhaps there'll be more reliance on that. Although I always tell arbitrators, if there's a teenager in your life who comes cheap, you can always look to that.
Yeah.
Well, I have a chance to introduce myself here. I don't know how this is working. Is this a panel? Are you, and I'm listening, or what?
Yeah, well, if you have a question, put it in the chat box and we'll circle back around to that at the end.
Okay, thank you.
Great, thank you.
I'm sorry, I'm late.
Okay, so where were we? One thing that that I have noticed, and I don't know, all the presenters could weigh in here. By virtue of the fact that we do these via Zoom or some other platform and it requires some pre-planning, I think that there's some risk there that it becomes, instead of what I've always been called, one of my old partners used to call labor arbitration trial by ambush, that it becomes now more mechanized, more process oriented on the front end, which that's really good in terms of planning. It also puts in a little bit of a, I won't say gamesmanship, but more legal strategy, more legalization, if you will. So I've seen some issues come up that early on in the process now that used to come up at the hearing. And so there are issues that have to be dealt with at some point in time. Have any of you seen, is my experience unusual in that regard?
I think the parties are really I get the sense that the parties like the preliminary discussions. They like the opportunity to, you know, develop stipulated facts, exchange your documents. You know, if I can recalling from my advocate days, that would have been, that's a plus to not to know what I'm going to expect and anticipate at the hearing, as opposed to, you know, am I going to walk in and all of a sudden there's going to be an arbitrability objection or something like that, and you know, so then you got to, you know, switch gears real quick and deal with that. But if going in on the front end, I think that makes the process flow better. If on the front end the parties can have those discussions, they are doing an early evaluation of their case, right? To make sure that it is meritorious, or they can prepare better for their theory. And I think it's a huge advantage for the process. I think it serves the process very well.
Yeah, I think it's an advantage, but I think that I get into some of those issues early on. I think it's good, but it has some challenges too. So Frank or Arthur, are you seeing anything on your administrative end that's causing issues in the pre-hearing phase with this?
Well, I already mentioned the one thing, and you know, they'll often turn to us if they're over any issue in the pre-hearing phase, even though we don't have jurisdiction to you know, to make decisions once the arbitrator has been appointed to the case. But you know, and I think lawyers will always find a way, if they can find a path to make things more legalized and, you know, maybe run up the tab a bit, they will find a way. I'm still a member of the bar, so I get to say that.
Yeah, right. Frank, you were going to say something, I think.
Yeah, and I think while having the pre-hearing conferences does kind of open the door for certain things, I mean, it's things that were going to come out of the hearing anyway. And I find that it's addressed a little earlier. And a lot of the things that are addressed at the pre-hearing are things that would have taken up valuable hearing time. So when the hearing is ready to go, you just opening statements, we just start to go. So it saves time. It's a valuable, I think, experience to do this, even though, of course, it's very novel to labor to do that.
Yes. Yeah.
One question, and I agree, it's very valuable. One question is whether arbitrators are billing for that, and you know, because parties traditionally don't expect to pay for pre-hearing, and but if it becomes more of a to-do than normal, you know, what is the expectation going to be? And I think it varies among arbitrators. You would be surprised. I mean, it's a business decision more than anything else, but some arbitrators are quicker to bill for small things than others.
Yeah, I see that as the scheduling process, primarily because I have not had disputes connected with the pre-hearing process. I have not had I haven't had the parties reach out to me to say, can you help us resolve which exhibits should be submitted and things like that. They do that pretty much on their own. And you know, the advantage to me is that I get a nice list of documents already organized and labeled, and like Frank said, you know, when it's time for the hearing to start, we're ready to go. So, but I would imagine there could be some, you know, but even before this, you may have had to get involved in a conference call with the parties on a scheduling issue. Um, you know, so I equate I equate them to one and the same. What I'm not seeing really is the parties wanting to do a test run. They're
very familiar with the process. It appears they're becoming very competent and capable of managing the use of the features of the virtual hearing. And so I'm not getting those requests like I had been earlier on.
But what about their witnesses, people that have, you know?
I think they practice with them offline so
Mhm.
that, you know, the day of the hearing, they're comfortable as well.
Yep.
The biggest
They could-
challenge I have with witnesses is the weird names that they have on their devices. So I can't tell who to let into the hearing room.
Right. Yep. I agree with all that. I agree with all that. Yeah. Yeah. On the billing piece, yeah, I mean, for me personally, that's scheduling, that's administrative, that's not, you know, if it's not substantive, it's not billable, you know, that's kind of the way I look at it. So personally speaking, but Jeannie, you said something about talking about resolution, whereas you might have had that conversation when you show up at the hearing. Now you may have that conversation in the call. Does that make it easier? Has that been more effective that way to do it on a call, to talk about, okay, have y'all, I'm presuming you all have discussed any way of resolving this short of a hearing, and you know, have you all had that discussion, I presume, kind of talk?
Yeah, I don't generally ask that.
Mhm.
I presume that they want to go forward with the hearing unless they
Right.
tell me that they're settling. Um, you know, and now that's one thing I will say might be different about the virtual environment as compared to the in-person. Sometimes in person, I have let my instinct tell me that maybe I should have that conversation with them just because of the vibe that I'm getting in the room. I really don't have the ability to assess that virtually.
Right. Right.
So
Um, I wanted to kind of circle back with Arthur and Frank on, and Arthur's mentioned this in terms of the um, challenge of agreeing or not agreeing to virtual versus in person. But what other than that, what do you all see, Frank and Arthur, in terms of what does other than that challenge, which Arthur has spoken to, but how does what involvement, what challenges do you see as an administrative agency in this world of virtual hearings going forward in the future, beyond what we've already talked about?
Well, I would say that, you know, there's always going to be some technological issue. I mean, I don't know if you've seen this already, maybe anyone on the call, sometimes a witness is in the middle of testifying and they disappear, right? That can't happen in the real world. And
Mhm.
sometimes it happens virtually. So it's a little odd. You get a kind of, everything grinds to a halt while they try to get the person back on. So you're going to have these technical issues, probably in some respects balanced by the fact that, you know, people aren't going to be late. There's really no traffic issues, no travel hang up. So, you know, if someone has to just go to their room in their house where they're going to manage this or appear, it's a little easier that way. So, but as far as technologically, you know, you're going to hit issues now and then.
Yeah.
In terms of, sorry.
Go ahead, Arthur.
No, go ahead, Mark.
Okay. Something just occurred to me. I know that in the employment realm, that AAA offers some technological assistance, I think, to parties. You know, that the need for that may be waning, like we're talking about now. But do you use that in the labor context as well? Is that available in the labor context and labor arbitration?
It is.
Okay.
It is, and there's different levels of service. One of the more popular ones is we do the invitations, we get the room set up, get the breakout rooms ready, and then will generally hand it over to the arbitrator, or perhaps if there is a court reporter, someone in a neutral capacity who would then take it from there. We do charge a nominal fee for that.
Okay.
In some cases, they do want us to be there for the entire proceedings, which of course is a little more costly.
Yeah, yeah. Anecdotally, I guess, but do you see, again, the need for that waning now? Is it, or either in, I guess I should say either in employment or labor. I'm going outside the scope there a little bit, but
Yeah, I don't really have the data for outside of labor.
yeah.
But labor, it's been pretty consistent. It
Really?
peaked in about October. It was steadily rising, and then October, it's been pretty stable since then. But you know, it's still been a service that people seem to want. A lot of arbitrators like it as well. One less thing they have to worry about. They just manage the proceedings themselves. They don't have to worry about the technical aspects as well. So
Right, yeah. Okay, I'm gonna advance the slides there a
Before you
little
leave
bit.
this, before you leave
Yeah.
that point, Mark, if I
Yeah.
can just interject one other, I
Yeah.
guess, piece of advice I would say is that I think that to the extent that we are holding these hearings virtually, that they really should try to emulate in person as much as possible. That's something I really try to stick to when I'm running a hearing. You know, if you're in the hearing room, you're on camera. You know, unless there's like some extenuating circumstance. Otherwise, you're in the waiting room. So, just like in a hearing room, the people are there in the room. You're engaged in the hearing or you're not. Um, you know, so I think that it's important to kind of encourage the parties and to promote that messaging as we preside over these hearings to keep the parties, you know, confident in the process.
One of the
That-
challenges
Yeah.
is, you know, we enforce the code of professional responsibility on our arbitrators. And I think there are ethical issues, particularly the one addressed in the Academy's advisory opinion 26 about the use of video. And I think there are other ethical issues that may be arising. And so just in terms of that question that you had on the table, I think that is something we could potentially see more of over time.
Yeah.
Speaking of arbitrators and ethics, I mean, I heard one story told of the arbitrator kept checking his cell phone during the whole hearing, like just interrupted the hearing to check the cell phone. I was just floored by that.
Well, Jeannie,
And-
at least he was awake.
Well, yeah, that's true. Oh, and I've actually had a court reporter fall asleep on me recently, which I had never seen that happen.
Mhm.
I was like, it's usually the arbitrator, not the court reporter. But yeah.
But you
learning
raise a
all kinds-
good point. You raise a good point about decorum, okay? Because just yesterday, I was in a mediation and a lawyer from Florida told me that I wouldn't believe, we were talking about arbitrations, and he said, you wouldn't believe the orders that come out from the courts in Florida about just because you're on Zoom doesn't mean you don't have to dress appropriately and conduct yourself appropriately
Sure.
that you would otherwise be in court. And I sort of, mediations might be a little more relaxed, but in arbitration, nope. It is a hearing. It is still a relatively formal process. So not so much like in court, but at least in terms of your decorum, it should be guided accordingly. So it's a good point. Very good point. Okay, so again, we're just a roundtable discussion here, and this is really about, there's some overlap here on this slide and what we'll be talking about in the next session, but because we don't want to leave any particular topic out, this does deal with the process itself, and we'll talk about the bigger picture in the other session about diversity and the expansion of the practice. So what is, and this is really more of a administering agency, Arthur and Frank question, but talk a little bit about what you all are doing, your respective agencies are doing in the area of diversity and inclusion in terms of panels and selection.
Sure.
Arthur, go ahead, Frank, go ahead.
Yeah. So, for labor, about a third of our roster currently identifies as diverse, and that's about a third of the appointments as well. So it's nice to see there's a balance there, things are lining up. Of course, we're always searching to make sure our panel is as diverse as possible. And you know, I mean, and just in speaking to union leadership, they said, you know, we'd like to have arbitrators who reflect the bargaining unit to the extent possible. Then when we get a list, we like to see that diversity. So it's certainly something we hold dear, especially not only just the fact that it's an important part of our social structure, but also the parties seem to want that as well. So double two good reasons for that.
Frank, I assume that when you say a third, that women are
Yes,
included. Yeah.
Exactly. Yes.
Yeah. As far as what we're doing, I mean, this has long been a challenge. Particularly, I think there's been. I mean, I don't have good statistics on this, but I think there's been faster growth in bringing women onto rosters and into the academy, for example, than minorities, and that is something that's long been a challenge. I know my predecessor, most of you know, Bella Trainum. She struggled with that for years, and she always said part of her struggle was she didn't know how much she wanted to encourage minorities to become labor arbitrators because it wasn't necessarily a moneymaker. So that is a consideration, but all of us know that in labor arbitration, for sure, minorities are woefully underrepresented. We have been doing a number of things. I mean, particularly in the area of recruitment, I've spent a lot of time doing outreach in all kinds of different ways as far as recruitment. We established, I mean, one of the things, and this is a burden for everybody, regardless of your ethnicity, but I think it has in the past disproportionately burdens newer arbitrators. And that is, you always had to have, even if you took our training course, you always had to have 2 arbitrations still, rather than 5 awards. And it was always that, catch-22. Well, how am I going to get those? So we created an apprenticeship program where those who took our training could then do an apprenticeship where they worked with 1 or 2 members of the academy to go to hearings and do shadow awards, which could count instead. And another thing, new arbitrators, as everybody know, in general, are disadvantaged. It's really hard to break into. And we're getting more minorities as new arbitrators as time goes on, but it's hard for them to break in, just as it is for anybody. So one of the things, we've done a little bit of this, but one of the things, once we get over, we could be doing it online as well, is having programs where, get to know the new arbitrators. And we can't, certainly as a federal agency, we can't say, get to know the new minority arbitrators, but getting to know new arbitrators in different regions and so forth, inviting parties to come and do that. I think when you have the face and you've heard from them just a little bit, it makes a difference. You'll recognize the name when it shows up on a panel. None of those are great solutions, but Those are some of the things that we're doing to at least make adjustments over time. Another aspect of a different aspect of diversity is age. Arbitrators, don't generally ride off. I mean, some of them do, but they don't generally ride off into the sunset. They have to be carried off.
Right. Yes. Yes.
My comment on that would be it too, is that the question really needs to be directed to the advocates, because they are the decision makers, and perhaps the appointing agencies in partnership with advocate organizations can really work on that. I know as arbitrators and academy, we are focused on mentoring as a way to increase diversity. And as an arbitrator, oftentimes we may be asked to make recommendations for arbitrators, and that's where we can do our share. But I think it's critical that the advocates have a stake in this, and that they are on board with making a shift.
Absolutely.
That's where those regional meetings can have such an impact. NAA meetings, LIRA regional meetings, labor management centers meetings, organizations can have such a role in that too. And I've always been a proponent of that. Just one other, I haven't been keeping track of the chat. I know we've got a lot of comments in there. I can see the number, although I haven't read them. Something that's always been a challenge for me, or a question I've had, and I put it forward to all of the presenters here, but I'm always curious as to why we don't see more hybrid modes of resolving these cases short of arbitration. Not to say that we're not cutting off our nose to spite our face in that regard, but we've all, as arbitrators and advocates, or as even in administrative agencies, probably known cases where you walk out of there and say, why am I here? Or this really should have been, and you don't know what other political motivations, internal political motivations may be at hand. So do you see any increased use of that, or emphasis of that, or a role for those sort of hybrid processes going forward? And then we'll move on to our chats. And just briefly, if y'all can address that.
I'm not aware of a particular trend. Med-arb is something that I think it tends to be you love it or you hate it. I think people that come from a general dispute resolution background think it's a good way to spoil two different kinds of dispute resolution all in one. But others, have found, it's what the market wants. I'm surprised there isn't more use of the other way around, arb-med, which actually enhances both processes, although it can be less efficient than what med-arb aspires to.
And I think obviously that it's up to the parties to either negotiate that into their collective bargaining agreements. I do know that there are some who have that. And, I serve on a panel where they use med-arb. But I think that it may be useful to take a look at the process, to the extent that there may be some COVID-related backlogs. And that may be a good way to get some of those cases resolved quickly, either by grouping them and sending them to a mediation arbitration process, or an expedited arbitration decision-making process.
Yeah, and from what we're seeing here at the association is more, it really, if it's in the contract, which is extremely rare that it would be, a lot of times parties at the instant hearing may then convert it to a mediation and try it that way. That's probably what we see most often. And then right now and then, of course, I know you'd mentioned that expedited arbitration, you know, we do see that on occasion, and it can work wonderfully if
Right.
everyone's willing to follow very closely, because it is very restrictive. You know, you get the 1 day of hearing, you get no stenographic record, no briefs, and a 7-day decision. So the arbitrator themselves also has to really put that as a forefront. But so
I mean, with us, they can request a panel of arbitrators willing to do expedited.
Mhm.
Exceedingly rare for us to get those requests, however.
Mhm.
So,
Right. Okay, I'm sure we've got 8 or 9 minutes left, maybe not quite that much, maybe 7 or 8. I'm gonna Mark Goff, are you ready to kind of run with the questions? I know we've got several there, comments or questions. I can't really tell at this point because I haven't been watching it. Can you pick up and run with some of those comments and questions?
I am, yeah. So I think a lot of the comments involved you know, how to handle documents in the new environment. And I think the conversation collectively can be described as kind of what new norms have developed or will develop. So the first question was asking, is the FMCS planning on creating like a Zoom roster for local and regional hearings?
yeah, I'm not exactly sure. I saw that question. We already do have arbitrators are able to self-certify as ready, willing, and able to conduct virtual arbitration, virtual hearings, and parties can request a panel of only arbitrators who are ready, willing, and able. It's up to the parties to decide whether they want to have geographic restrictions. I mean, in general, unless it's, oh, I want to be more familiar with my, local arbitrators. In general, there's no reason to have geographic restrictions, but that it seems in most cases, they're still putting some kind of geographic restrictions. So in that sense, we already do have a roster. I will say, and this has surprised me, because we also have the option, and if both parties have to agree to either or both, we also have the option of checking a box that says, I want all of the arbitrators to be ready, willing, and able to conduct an in-person hearing. That's for COVID times. What has been very surprising to me is only a very small percentage of our panel requests designate either of those. The vast majority don't check either box. And I don't know if it's because the parties can't agree or because, they want to be surprised how it works out.
Thought about it later.
Yeah, or discuss it with the arbitrator. I don't know.
Does AAA have a process where you check that, Frank? I'm sorry for.
Yeah, so we basically leave it up to the individual arbitrators to actually put it on their resume as to what they're comfortable doing, and of course, the vast majority, if you had to balance it, would rather do a virtual hearing than an in-person one under these times. But clearly, that is something that's due to the ongoing pandemic. But if there was some gray area with that, then if the arbitrator was insistent that for whatever reason their circumstances required that I can't do any the rest of the year in-person hearings, we just handle it as a disclosure. So we just let the parties know this is the circumstances. Do you want to continue with this particular arbitrator, or should we move on to somebody else?
And what if
Mark, I'm
Frank,
sorry,
what if the parties
I
don't
jumped ahead.
agree?
Then we, of course, under the rules, we'd make that decision.
All right, so the next question had to do with table control issues and whether remote hearings have exacerbated any table control issues. And Gina, I'm actually going to also tie this into your comments about trying to keep the norms of the in-person hearings while, in the during Zoom hearings. And so can you address specifically table control issues, but then broader, what norms do you find to be the most difficult to control?
I'm stumped because I really have not had any complications. I did see a lot of comments and questions about the document and looking at the documents early on and things like that, and whether or not they're going to all be introduced. And as a practice, I don't look at the documents, even though I receive them early. So I manage that just like the hearing as well. In an in-person hearing, I wouldn't get the documents till I walked through the door. Only to the extent that I put them together in some organized format, but I don't study the documents because they may not all be entered into the record. Even with that, I really haven't had any challenges. And I think that the last minute introduction of maybe a rebuttal exhibit that can come through an email, and the parties have been very proficient at making that happen. So I really haven't seen any control, challenges to maintaining control.
Yeah,
And
all the feedback that I've
keeping
been
it,
getting. Oh,
yeah,
sorry.
keeping it as close to in person as possible.
All the feedback that I've been getting is that that hasn't been an issue, other than a couple of complaints where the arbitrator just hasn't gotten comfortable yet with the technology. But that's not so much an issue of table control as it is just technology, being sufficiently conversant.
Okay.
Yeah, we can rule on objections and everything the same. You can, shut people down, mute them. Actually, that's better.
Yeah.
That's a plus. And it has been very close to what I've experienced first, in person. You have a witness that doesn't want to answer the questions and all kinds of things, and I'm able to address it and handle it, and we move on. And I'm going to put a link in, not a link, but information about an upcoming event with the Academy, who's conducting a year in review kind of focus group on these very topics.
Good.
So if you're interested in attending, you can send in an email.
Yeah, I see the suggestion there in the chat box of putting them into a breakout room, kind of like a timeout. I like that.
Oh, I thought that was talking about somebody in this meeting, but anyway, no.
That would only mean me.
Yeah, that's a good time.
When I tried to go into the breakout room, I got disconnected, so
Yeah.
I'm staying right here.
I think we're to the end. Let's see. Was I supposed to do something differently? Well, I guess I can go ahead and wrap us up here. I do want to thank all the presenters, Frank and Arthur and Jeannie, for having this little roundtable discussion today. I hope it was helpful to everyone. I also want to thank Emily and Bernadette from the LYRA staff for really being the backup for all of this, and Dick Fincher for all his planning efforts, and also to thank all the sponsors for these discussions that we have had, the National Academy Research and Education Foundation, the AAA, and the Association for Conflict Resolution. We certainly appreciate all that assistance and so forth. And last but not least, please look into signing up and joining LYRA, and with that you get a free membership in the dispute resolution interest section. So with that, I think we are at our time, and I think the ladies can they can sign us off now, or I can stop it. So Thank you all. Hope you
Thank
come to
you.
the next one, which starts in 15 minutes.
Yeah, so
Yeah,
you can
and let's
welcome to
not
just
sign
stay.
off.
Stay
Let's
right
stay
here.
on.
Not sign off, not sign off, or stay on, stay on. I'm sorry. That's right. Thank you,
Mark
Mark.
Travis, you could pull your screen share down now, though.
Okay. Mark,
Thank
okay.
thank you all.
Thank
you.
you.